On June 29, 2026, the Supreme Court handed down two rulings, Watson v. RNC and Trump v. Slaughter. Taken together, they dictate how votes are counted and who actually controls the federal government. These decisions represent the culmination of a highly deliberate, decades-long judicial project. To see the full picture, we have to look back to 2005, when John Roberts took the oath as Chief Justice. Since he assumed leadership, the court has undergone a documented ideological and structural shift that has altered the relationship between the three branches of government. The court has spent these 2 decades moving through a specific checklist, stripping away the mid-20th century regulatory baselines, centralizing authority within the executive branch, and returning the most explosive social questions to the individual states. To understand how the government operates today, we need to examine how legal precedent was rewritten across 5 distinct arenas. The first arena is campaign finance. In 1976, Buckley v. Vallejo set the standard. The court ruled that limiting independent political spending violated the First Amendment, but capping individual contributions was constitutional as a way to prevent political corruption. This timeline charts the methodical removal of those limits. Starting with the Wisconsin Right to Life case, corporate issue ads gained protection. Then, the 2010 Citizens United decision barred the government from restricting independent expenditures by corporations and unions, creating the Super PAC era. As the timeline expands to 2014 and 2022, the court continued this trend. It struck down aggregate donation limits in McCutcheon and later removed the federal rules governing how candidates repay personal campaign loans. Senator Ted Cruz served as the catalyst for that 2022 ruling, successfully arguing that limiting the use of post-election contributions to repay personal loans placed an illegal burden on political speech. Today, the court treats financial contributions as protected First Amendment speech, ruling that avoiding the appearance of corruption is no longer a broad enough justification to limit political spending. In the second arena, the court redefined the boundaries of presidential legal exposure. Historically, the guardrails were clear. A president was immune from civil damages for official duties under the Nixon standard, but had no immunity for actions taken before assuming office, a line established during the Clinton administration. Those boundaries moved in 2024 with Trump versus United States, a case that forced the court to evaluate a former president's criminal liability for the first time. This pyramid breaks down the resulting immunity framework. At the exposed case, a president has zero immunity for private acts. In the middle, they have presumptive immunity for official acts. But at the fortified top, they enjoy absolute immunity from criminal prosecution for actions taken within their core constitutional authority. By re-anchoring legal exposure in this way, the court fortified the executive branch and solidified a rigid structural separation of powers. The third arena handles the mechanics of voting. In 2013, the Shelby County decision eliminated the pre-clearance formula from the Voting Rights Act. This shifted election authority away from the federal government and back to local jurisdictions. That balance between federal oversight and state authority was tested again on June 29, 2026, in the case of Watson v. RNC. The court endorsed state grace periods, confirming that states possess the constitutional authority to count mail-in ballots postmarked by Election Day, even if they arrive several days later. This confirms the court's broader election strategy, prioritizing the authority of state legislatures to manage their own voter access rules. The fourth arena focuses on the administrative state. For nearly a century, the Humphreys executor president protected members of independent agencies from being fired by the president without good cause. This originally insulated multi-member boards, like the Federal Trade Commission, allowing them to operate as independent regulators regardless of who was in the White House. The first major crack in this foundation appeared in 2020. The court ruled in SELA law that an agency led by a single director, shielded from removal without cause, violated the separation of powers. Then came the June 2026 ruling in Trump v. Slaughter. The court applied that 2020 logic to all multi-member boards, effectively ending the Humphreys framework. On this chart, you can see the result. The good cause barriers that once protected these agencies have been removed. They are now rerouted directly under presidential removal powers. This ruling realizes the unitary executive theory, granting the president direct control over the federal regulatory apparatus. The fifth arena involves stripping federal agencies of their interpretive power. In 2024, the Loper-Bright decision ended 40 years of Chevron deference. This took the power to interpret ambiguous laws away from administrative agencies and returned it to federal judges. The court took a similar approach to social flashpoints. The 2022 Dobbs decision overturned Roe v. Wade, ruling that the Constitution does not confer a right to abortion and returning that regulatory authority to individual state capitals. This rollback of federal oversight continued in 2023, when the court ruled that race-conscious affirmative action admissions programs in higher education violated the 14th Amendment. Federal regulatory agencies have been significantly weakened, while major social questions and foundational rights are now decided locally or through the lens of historical tradition. The mid-20th century regulatory baseline has ended. Federal agencies have lost their independence from the White House, and interpretive power has returned to the courts. In its place, the Roberts Court has built a system where state legislatures possess the authority to manage social policy, while the executive branch exercises direct dominance over the administrative state. This leaves Congress in a landscape where its legislative output is now balanced against a supercharged executive and a judiciary that serves as the final interpreter of the law. Over 2 decades, the Roberts Court has methodically altered the internal mechanics of American governance, establishing the legal architecture that will define the nation for the next generation.